The officer has not given you a breathalyzer. He has not run a single test. He does not have one piece of evidence. And yet, in about 30 seconds, most drivers hand him everything he needs to make a DWI arrest, and they do it voluntarily, out loud, with a smile on their face. Because when a cop leans into your window and says those 5 words, "I think I smell alcohol," something automatic happens in the human brain. You want to explain. You want to defend yourself. And that instinct, that completely natural, completely human impulse to just talk your way through it, is the most expensive mistake you will ever make at a traffic stop. I have spent years reviewing DWI cases, studying body cam footage, and reading the suppression hearing transcripts that most people never see. And I can tell you with absolute certainty, the drivers who got arrested did not lose because of what the officer found. They lost because of what they said. Tonight, I am going to give you the exact words, backed by constitutional law and real case precedent, that shut down this interrogation technique before it builds a single piece of evidence against you. No arguing. No rudeness. No silence that gets twisted into something suspicious. Just the right words, in the right order on camera. This is educational content to help you understand your constitutional rights. For advice specific to your situation, always consult a licensed attorney in your state. And if this channel is new to you, subscribe right now, because the next video covers what happens when the officer orders you out of the vehicle, and the words you need in that moment are completely different from these. Missing that distinction has sent people to jail who had done everything else right. Here is the first thing you need to understand, and once you hear it, you will never hear those 5 words the same way again. Alcohol does not have a smell. It is chemically odorless. What an officer claims to smell is not alcohol. It is the beverage the alcohol happens to be in. Beer. Wine. A mixed drink. The alcohol itself has no odor. Officers know this. They are trained on this. And they use it anyway because, "I think I smell alcohol," is not an observation of fact. It is the opening move of a structured interrogation technique taught at the academy. Think about what happens the moment those words land. The officer does not know whether you have had 0 drinks or 10. He has nothing. No test results. No erratic driving documented beyond whatever the traffic stop was for. He has 5 words and a blank report. But the moment he says them, something predictable happens. The driver wants to respond. "Oh, officer, I only had 1 beer at dinner, like 3 hours ago. I'm completely fine, I promise." And in that one sentence, the driver has just handed the officer an admission that alcohol was consumed, a timeline the officer can use to calculate blood alcohol level on the witness stand, and a consent argument if he adds, "Smell my breath," or reaches toward the officer. 3 evidentiary gifts, all volunteered, all recorded, all before a single test was administered. That is not cooperation. That is the case building itself. Officers are trained to know that once you are standing outside, or even just sitting there with the pressure of those 5 words hanging in the air, the talking starts almost automatically. They are not trying to have a conversation with you. They are trying to fill a report. And every word you give them is another line they did not have to work for. Now let us talk about what most drivers do in this moment, and why both instincts destroy them. The first driver talks. They explain, they justify, they try to reason with the officer. "I had 1 glass of wine with dinner, that was hours ago, I'm not drunk." They genuinely believe that a calm, honest explanation will satisfy the officer and end the stop. It will not. Every admission, every timeline detail, every apology becomes evidence. Officers are not deciding whether you seem honest. They are building probable cause, and your words are the easiest raw material they will ever collect. The second driver goes cold and combative. They refuse to speak, they stare straight ahead, they make the officer feel challenged or disrespected. Now the report reads, suspect was uncooperative, suspect appeared agitated, suspect's behavior was consistent with intoxication. Juries do not like defendants who are rude to officers. Prosecutors know this and they use it. If the officer can paint you as hostile or aggressive, your credibility in that courtroom drops before you say a single word in your own defense. So you cannot talk your way out. You cannot be rude. And simple silence, while constitutionally protected, can be misread and misdescribed in a report in ways that hurt you. What you need is something completely different, a response that is calm, polite, specific, and constitutionally airtight. A response that gives the officer absolutely nothing to work with, while simultaneously putting him on record. Here is what the law actually says, and this is the part officers are counting on you never knowing. It is not illegal to drink and drive. It is illegal to drive while intoxicated. That distinction is not a technicality. It is the law, and courts across the country have been absolutely explicit about it. The odor of alcohol alone, even if the officer genuinely smells something, is not sufficient probable cause for a DWI arrest. The Kansas Supreme Court said so in State v. Stevenson. The North Carolina Supreme Court said so in Atkins v. Moy. Courts in Tennessee, Alaska, Ohio, Wyoming, Colorado, Wisconsin, Louisiana, and Washington have all ruled the same way. The smell of alcohol, without additional evidence of impairment, does not justify an arrest. Which means the officer's entire opening move, "I think I smell alcohol," is legally insufficient on its own. He needs more. He needs your words. He needs your admissions. He needs you to give him the probable cause that the smell alone cannot provide. And the moment you understand that, the correct response becomes obvious. So here are the exact words. The moment the officer says, "I think I smell alcohol," you respond calmly and clearly. "Officer, I exercise my constitutional right not to answer questions about what I've had to eat or drink. Am I free to go, or am I being detained?" Say it once. Say it politely. And then stop. Let me break down exactly why every part of that response works the way it does. "Officer, I exercise my constitutional right not to answer questions about what I've had to eat or drink." This invokes your Fifth Amendment right in the most precise and targeted way possible. You are not refusing to speak to the officer entirely. You are specifically declining to discuss the one topic that builds his probable cause, what you consumed. That precision matters enormously. With body cam footage running, there is no credible way for the officer to write in his report that you were combative or uncooperative. You spoke. You were polite. You addressed him directly by his title. You simply declined to incriminate yourself, which is your absolute constitutional right. Once you have provided your license and insurance, you have no legal obligation to answer any further questions about your personal conduct. Not one. "Am I free to go, or am I being detained?" This forces a legal declaration on camera. The officer must now commit. Either he lets you go, in which case the stop is over, or he tells you that you are being detained, at which point he is legally required to articulate a reason. Independent, specific, articulable reasonable suspicion beyond the smell claim. That question shifts the burden back onto him, exactly where the law says it belongs. Now the officer is going to push back. He always does, and knowing what to say when he does is just as important as knowing the first response. If the officer says, "Look, if you've got nothing to hide, just tell me what you had to drink tonight," you respond, "Officer, I once again exercise my constitutional right to remain silent, and I will not answer any further questions until my attorney is present." Say it the same way. Calm. Polite. firm. Your invocation of the right to remain silent cannot be used as evidence of guilt. No court in this country allows that. It is not incriminating. It is not suspicious. It is your Fifth Amendment right exercised out loud, on record, on camera. If the officer responds to your invocation by ordering you out of the vehicle to perform field sobriety tests, understand this clearly. Under Pennsylvania v. Mims, he can require you to step out. That part is settled law. But your decision to perform field sobriety tests is voluntary in every single state. There is no law that compels you to take them. And here is why that matters far more than most people realize. You can be completely, stone-cold sober and still fail those tests. Walk and turn. One-leg stand. Horizontal gaze nystagmus. These tests have standardized clues. And if you start before the officer finishes the instructions, if you use your arms for balance even slightly, if you take 8 steps instead of 9, those are clues. Clues that go in the report. Clues that get shown to a jury. You can blow zeros on a breathalyzer and still fail a field sobriety test because you did not execute a 3-point turn with perfect precision on the side of a highway at night with headlights in your face and an officer watching your every movement. The correct response the moment tests are mentioned is, "Officer, I only agree to perform these tests with my attorney present after the opportunity to seek counsel." Say it calmly. Repeat it if necessary. And if the officer arrests you anyway, the first words out of your mouth after the handcuffs go on are 4 words only. "I want an attorney." Under the Sixth Amendment, that invocation ends all interrogation immediately. Everything from that point goes through your lawyer. Do not explain. Do not clarify. Do not try to make the situation better with words. You have already said everything the law requires you to say. There is one more layer that most people never consider, and it is the one that determines whether this all works in court. Everything you say on that roadside matters. But so does how you say it. Tone, body language, and conduct are all captured on body cam, and they all end up in front of a jury if the case goes that far. The drivers who protect themselves most effectively are the ones who are calm, polite, and deliberate, not cold, not robotic, not aggressive. You can be a decent human being and still exercise every constitutional right you have. Those are not in conflict. Staying calm keeps the officer's report clean. It keeps the body cam footage working in your favor. It makes it harder for a prosecutor to turn you into a villain in front of 12 strangers. The fight, if there is one, is never on the side of that road. It is in a courtroom, where a judge will watch that body cam and see exactly what you said, when you said it, and how you said it. Your job at the traffic stop is only this: give them nothing, stay on camera, and say the right words. Memorize these before you close this video. When the officer says, "I think I smell alcohol," "Officer, I exercise my constitutional right not to answer questions about what I've had to eat or drink. Am I free to go, or am I being detained?" If he pushes, "Officer, I once again exercise my constitutional right to remain silent, and I will not answer any further questions until my attorney is present." If field sobriety tests are mentioned, "Officer, I only agree to perform these tests with my attorney present after the opportunity to seek counsel." And if you are placed under arrest, "I want an attorney." For responses, every one of them backed by constitutional law and real case precedent. None of them require arguing. None of them require rudeness. All of them work because they are specific, they are polite, and they give the officer nothing he can use to build his case. This is educational content only, and does not constitute legal advice. Always consult a licensed attorney in your state for your specific situation. If this video reached you before your next traffic stop, it did exactly what it was meant to do. Subscribe to this channel right now, Because what happens after the alcohol claim is just one piece of a much larger picture. The next video covers the moment the officer says, "Step out of the vehicle," and the constitutional framework that protects you in that moment is completely separate from everything covered here. Every video on this channel is built to close the gaps that leave people exposed at traffic stops. One scenario, one set of exact words, one piece of case law at a time. Subscribe. Share this with someone who drives. Someone watching this tonight might face those 5 words tomorrow morning, and the difference between driving home and being booked into a county jail is going to come down to what comes out of their mouth in the next 30 seconds. Make sure they know what to say. Stay calm. Stay protected. Stay free.